This is a relatively short podcast about how new technology does fit within the traditional rules. So we had some comments in the last podcast about how no universal rule can apply, but in Rudder and Microsoft you see that there are new cases coming before the courts about new technology and how the courts are going to be applying the rules. In Rudder and Microsoft, the plaintiffs commenced class action proceedings for breach of contract and fiduciary duty, claiming that the defendant, Microsoft Corporation, misappropriated credit card funds and gave inaccurate information regarding accounts. The defendant sought a stay of proceedings on the basis that the plaintiffs had agreed to exclusive jurisdiction of the King County Courts of the State of Washington in the online agreement. The plaintiffs argued that the forum selection clause should be treated as fine print, since only a portion of the agreement was available on screen at any time, and that it should have been brought specifically to the intention of the party accepting the terms. Since it was not, it should be severed from the agreement. The ratio that comes out of this case is that the normal rules of contract formation will be applied to agreements created in electronic format. So contract is formed on the basis of clicking the I agree icon on the screen. And acceptance applies to all the terms set out in the agreement displayed on the offeror's website, including those not read by the offeree. The reasons were that the court rejected the fine print analogy. It's plain and obvious that there was no factual foundation to the assertion that any term of the membership agreement was fine print. The online agreement was in a computer-readable form, which was readily viewable by scrolling through the agreement. All of the terms were displayed to the offeree in the same format, and there was no fine print. Although the entire agreement could not be displayed at once, that's not materially different from a multi-page written document. The terms are presented twice, and each time the member must accept. Failure to do so terminates the registration process. The policy reason is that you have to advance certainty, commercial certainty in an electronic environment. Chaos in the marketplace would happen if you render ineffectual e-commerce and undermine the integrity of any agreement entered into through this medium. This case tells us that a process that forces a customer to navigate past carefully drafted terms and indicate acceptance of those terms before submitting an order is going to be binding on the consumer. In another case, Hill and Gateway, the issue is whether the plaintiffs, who were purchasers of a computer from the defendant over the phone, were bound by an arbitration clause. And the judge said, quote, "A contract need not be read to be effective. People who accept take the risk that the unread terms may in retrospect prove unwelcome. It was enough that the plaintiffs knew there were terms, even if they didn't try to discover what they were." Another factor there was that the plaintiff kept the computer for more than 30 days before complaining. And to that, the judge said that those who may not be able to discover the terms of sale made at a distance have an opportunity to return the goods when they discover those terms, but that step has to be made quickly. So contracts made over the internet present a slightly different picture. There is no negotiating. The notice of acceptance will be the offeree's simple assent to the term on the website, simply by clicking an I agree icon on the screen. Now, note that these cases were from, so Hill was from 1997, and Rudder was from 1999. So things have gone, have progressed quite significantly since then, and now many of our contracts are made on the internet, and as we will be talking about later on this year, we have a lot of standard form agreements for pretty much all of our services, all of our transactions, and these standard form agreements present exactly the same problems that were discussed in the Hill case, which is if you don't read the agreement, it doesn't mean that you are not bound to it. This can be through the computer. This can also be through a tangible agreement that you're flipping through. We will come back to these issues. Finally, Finally, I wanted to bring to your attention the Electronic Transactions Act in Alberta, which simply says that a contract is not invalid if it is in electronic form. So it recognizes electronic signatures. It says that the use of the words in writing or signature does not of itself prohibit the use of information or records in an electronic form. It says offers, acceptances, and other relevant communications are expressed electronically by clicking the icon on the computer screen unless the parties agree otherwise. It says that the document is sent when it enters an information system outside the sender's control. And e-documents are presumed to be received when they enter the addressee's information system, and it is capable of being retrieved by the addressee. Note that the legislation does not say anything about issues like contract formation, except to say that the legislation recognizes the validity of documents formed by electronic communication. The legislation does not say anything about the rules that should govern the communication of acceptance. Also, there is difficulty in enacting legislation to govern contractual relations made over the internet. By its nature, people may be in jurisdictions far beyond the control of any provincial legislature or parliament. So the development of e-commerce makes it harder to protect consumers. Even if you did have the application of the postal acceptance rule such that the contract is concluded when and where acceptance is posted, so where the consumer is, the problem is that if there's fraud or cheating in any way, it may still be out of the reach of Canadian control. This legislation has been enacted all over Canada due to the anxiety over e-documents that arose when they started becoming more popular. This last slide is simply a chart for review about the rules of communications that are instantaneous and non-instantaneous.